Hello students, good evening. Good evening everyone. I hope you all had a very great weekend and you enjoyed your weekend. Okay, so in the last class, that is on Friday, we were discussing about acceptance and we discussed some rules related to acceptance. Acceptance is when you understand the offer and you want to enter into the contract with the other party, you accept that offer. You give your consent on that offer that yes, I'm willing to whatever you are wanting me to do, I'm willing to do that. That is acceptance. Again, we discussed many rules regarding acceptance, that acceptance should not contain such terms whose non-compliance will amount to acceptance. Acceptance must be unconditional, etc., etc. I think we discussed that, right? Or we had to start acceptance. Okay, I think we just completed offer, right? And acceptance was to be started. Am I right? Okay, I think we just discussed offer and today we'll have to start acceptance. So we are studying from the module itself. Topic is 1.2.3. Okay, page number 26. Page number 26. Section 2 subsection B contains the definition of acceptance, which says that when a promise is accepted, when a promise is accepted, it is known as acceptance. When you give your consent upon something, that is yes, when you agree upon something, then there you are giving your acceptance. Like for example, I told you I want to sell my book for rupees 200 to you. Are you willing to buy it? You said yes, I am willing to purchase your book. Here you are making acceptance. You are making acceptance. That is, you are accepting my offer. You are willing to enter into a contract with me. When you say yes, when you say yes, there you are making, there you are giving your acceptance. Like we have discussed some rules about offer, we'll be discussing some rules about acceptance today. Okay, so first legal rule relating to acceptance is acceptance must be given by a person to whom it is made. Whenever you want to give your acceptance, it should always be given to the person who gave the offer to you, that is offerer. We already discussed the person who is giving the offer is offerer and the person to whom the offer is given is offeree. Offerer, offeree, promiser, promisee, one and the same thing. Both terms are just similar. So if some books use the term offerer, some books use term promiser. So it is one and the same thing. Offerer and promiser are similar and offeree and promisees are similar. Both are synonyms. Okay. So offer, whenever whosoever is giving you the offer, it is very necessary that you give your acceptance to that person only. Like I told you that I am willing to sell my book for rupees 200. Now if you are willing to purchase my book, then you'll come to me only. Okay, and you'll tell me yes, I'm willing to purchase your book. If you're going to somebody else apart from me, if you're going to my husband, if you're going to my agent, if you are going to my family member or my friend, anybody, that will not amount to a valid acceptance. A valid acceptance will be only when you are giving that acceptance, when you are giving that acceptance to me, that is to offerer. So it is very essential, if you want your acceptance to be valid, you need to give your acceptance to that person only who gave you the offer. Don't give your acceptance to anybody else. But in exceptional conditions, if the offerer is having any authorized agent. If he has appointed any authorized agent and he has given him permission that you can accept on behalf of me, like for example, I appointed Mr. XYZ as my authorized agent and I told him that you can enter into contract on my behalf. You can enter into contracts on my behalf. Now you can give your acceptance either to me or to my authorized agent. But in general situation, you can Am I audible and visible? Can you hear me? Am I audible and visible? Okay. So acceptance must be given to that person only who gave you an offer, but in certain circumstances, if that person has some authorized agent whom he has given authority to accept the acceptance on his behalf, you can give your acceptance to that person also. Second is acceptance can either be expressed or can be implied. Means either you can use words. If you are using words that yes, I am willing to purchase your book, there you are making an express acceptance. There you are making an express acceptance. Whenever you are using words either orally or in writing, there you are making an express acceptance. Sometimes you don't use words, sometimes you don't use words, your action implies acceptance. That is also a valid acceptance. Like for example, have you ever heard about auction, nilami? What happens in auction? You go, for example, if I am auctioning my cell phone, I will invite the bidders. They will come and start bidding for the phone. For example, I set a upper limit that the auction of the phone will start from rupees 10,000. Now the people sitting in the list of bidders, what they will do, they will give their bids. That means what? They are making offer. Now they'll start that I want to purchase this phone for 21,000. Somebody will say 22,000. Somebody will say 23,000, 24,000, and so on. So for example, last person said 30,000, and after 30,000, nobody said anything. Nobody bidded above 30,000. So I said the phone is being selling for rupees 30,000. I hope there is no bids above 30,000. I have a hammer in my hand. What will I do? Uh, I'll stamp that hammer on the table and I'll ask 30,001, 13,002, 30,003 sold. When my hammer will fall on that table, that means what? This phone has been sold for rupees 30,000. This phone is now being sold for rupees 30,000. This means what? Now my acceptance was not through words. When my acceptance was not through words but was through action, that is falling of hammer. Falling of hammer implies that I have accepted your offer and now I'll be selling my phone for rupees 30,000 to you. So this is also a valid acceptance. This is also a valid acceptance. So acceptance can either be expressed, that is you use the words yes, I am willing to purchase your phone, or it can be implied also, like fall of hammer. Like if you're doing like this, then this is implied acceptance. That is you are not using words, you are just showing your actions. Like somebody gave you something. Somebody gave you something and you want to purchase that thing, but you did not tell the seller that I want to purchase this, but you start utilizing that thing. You start utilizing that product, you start using that product. There also you made an implied acceptance that using a product will also ensure that you have accepted that product. Okay, so acceptance can either be in the form of words, that yes, I am willing to say purchase your, or yes, I am willing to sell, or it can be implied also, that is it can be used through it could be given through acceptance also. Next is accepting by performing conditions or receiving consideration. It means what? Acceptance can also be given by just simply accepting the conditions, just similar like implied condition, implied acceptance. You can sometimes just don't give your answer, you just accept by performing the conditions. Like for example, I told you that I will give you this book, I will sell you this book if you give me 100 rupees advance. If you give me 100 rupees advance. You did not said yes, you did not say no, but what you do, you come and give me, you came and give me rupees 100. Here just fulfilling the condition will also be acceptance only. So if you're sometimes just fulfilling the condition, then also there will be valid acceptance. Next is acceptance must be given to the offerer or any authorized person by him. This point is just similar like above. We have already discussed. That is you can give offer to only to offerer or to his authorized agent, not anybody else. Next is acceptance must be communicated by acceptor only. Okay, so just accepting the offer in your head is not enough. If you want to accept the offer, you need to give this acceptance to the other party also. That is, like for example, I was satisfied that I want to purchase your book. Now I was satisfied in my mind, but I haven't told the seller yet that I want to purchase this book. So here this is not a valid acceptance. Acceptance need to be communicated to the other person. If I'm willing to purchase this book, then I need to go to the seller and I need to tell that seller that yes, I will buy your book. Now this is a valid acceptance. If you're just accepting in your head and you're not communicating that same acceptance to the other party, then that will not be a valid acceptance. So it is very essential that you communicate your acceptance to the other party, that is to the offerer. And only I can give acceptance. Okay, if offer is made to me, if offer is being made to me, only I can give the acceptance. That is only offeree can give his acceptance. Nobody can accept on behalf of offeree. Like if I told you that I want to sell my book to you, then only you can give your acceptance. Nobody on your behalf can give the acceptance. But if you have any authorized agent, again, similar point just like above, if you have any authorized agent, if you have appointed a person and you have given him this authority that you can accept offers on behalf of me, then this acceptance will be valid if it is not coming by you also, but only in case you have appointed some authorized agent. If the offeree dies, If the offeree dies, then in that case, legal representative of the offeree can also accept the offer. Legal representative of the offeree can also accept the offer. But just remember one thing in this situation: if the offer is of personal, if his offer is of nature where personal skills are involved. Personal skills means, like for example, somebody asked me to paint his painting. Somebody asked me to paint a painting of him. Here my personal skills are involved in this contract. Now if I die, then in that case nobody can paint in the same manner that I used to paint, right? Because here my personal skills are being involved. So if your personal skills are involved in some contract, in some offer, then nobody can accept that offer apart from you. Not legal agent, not authorized agent, not legal IR. Nobody can accept except you. Okay, so where personal skills are involved, only the offeree can accept the offer. Nobody else can accept on his behalf, because their personal skills are involved. That is, your talent is involved there. Nobody can do the work in which you are expert. So it is presumed that whenever you are making a contract where some personal skills are involved, there only the offeree can accept the offer. Apart from that, general rule says that only that person to whom the offer is given can accept the offer, but in exceptional condition. That is, if he has authorized agent, then authorized agent has a opportunity, has a authority to accept on behalf of acceptor. Or in case the acceptor dies, in case the offeree dies, in that case his legal heir will also be responsible to accept the offer. I hope it is clear. Anybody has any doubt? Okay, next is acceptance must be given with a reasonable time and before the offer lapses. Okay, before that, one more point is there. Acceptance should be in prescribed manner only. Like for example, I gave you an offer that I want to sell my book to you. And I told you that you'll give your acceptance only by texting me on WhatsApp. You will give your acceptance only by texting me on WhatsApp. Here, valid acceptance will only be when you give your acceptance through WhatsApp. Now, for example, you called me and told me that yes, I'll purchase your book. This will not be a valid acceptance. Why? Because the manner of acceptance, like in which mode you'll accept this offer, was already prescribed in the offer. That is, when I made the offer, I made myself clear that if you want to accept this offer, you will have to WhatsApp me. You did not WhatsApp me, you called me. So this will not be a valid acceptance. Whenever a manner is prescribed in offer, whenever a manner is prescribed in offer, you have to make sure that you will give your acceptance in that prescribed manner only. If no manner is prescribed in the contract, if no manner is prescribed in the offer, like for example, I told you, do you want to purchase my book? I said nothing that how will you accept it, how will you give your acceptance. In that case, you'll need to accept in reasonable manner. You'll give your acceptance in reasonable manner. Reasonability is just the question of facts. It will differ from circumstances to circumstances. Like if you are residing in Tamil Nadu and I'm residing in Rajasthan, so best suitable mode will be either you call me, you WhatsApp me, you email me. Coming here in Rajasthan and just for saying a yes is not feasible, right? So reasonable method, reasonable manner of acceptance here shall be via WhatsApp, via call, or etc. If acceptance, mode of acceptance, manner of acceptance is clearly prescribed in the offer, then you are bound to give your acceptance in that particular method only, in that particular manner only. But if the manner is not prescribed, then you'll have to give your acceptance in reasonable manner. Next is acceptance must be given within a reasonable time and before the offer lapses. Whenever you are giving an acceptance, whenever you are giving your acceptance, that acceptance should not exceed the time limit. Like for example, I told you that I am willing to sell my book to you. You give your acceptance within 3 days. You give your acceptance within 3 days. Now it is very necessary that you give your acceptance within these 3 working days. If you give your acceptance after 3 days, I might not accept your acceptance. Okay. And I might cancel the offer with you. So it is very essential whenever you are making an offer, whenever you are giving your acceptance, and if some time limit is being prescribed in the contract, if some time limit is being prescribed in your offer, then you need to adhere, you need to stick to that time limit. If the time limit has been expired, if you give your acceptance after that time limit, then this acceptance will not be a valid acceptance. Now what if I have not decided any time limit? If I told you I want to sell this book to you, you give your acceptance whenever you want. Here time limit is not decided, but that does not mean you give your answer after 1 year. No. When time is not decided in the contract, then you need to give your acceptance in a reasonable time period. You need to give your acceptance in a reasonable time period. That means what? Reasonability, again, it is question of facts. It will depends upon the circumstances. Now, for example, if like I'm selling you a book, so reasonable time will be before completion of the course you give your answer, because after your course has been completed, after you give your exam, this book will be of no use for you, right? So reasonable time will be before completion of your course, before your exam. If goods are of perishable nature, that is goods will get destroyed after some period of time, if the goods will not be usable after some time, like for example vegetables have a very short time span. So if I told you that I want to sell 1 kg tomatoes to you, now here you'll have to give your acceptance within very short period of time. Why? Because life of tomatoes is hardly 4 days, 5 days, not more than that. Now if you'll give your acceptance after 10 days, tomatoes will perish and they will decay, right? So if goods are of perishable nature, you need to give your acceptance as fast as possible, because goods will perish after a very short period of time. So again, whenever you are giving your acceptance, first of all, just give your acceptance within the fixed time period. Don't give your acceptance after the expiry of time period. If time period is fixed, you give your acceptance in that time period. If time period is not fixed, then you'll have to give your acceptance in the reasonable time period. Here one very renowned case happened. It was Montefiore versus some company. It was some case like that. What happened in this case? Like for example, Mr. X purchased share of some company. Okay, Mr. X purchased some shares of this Montefiore company. Now what happened? Whenever you apply for some shares, the company law says that within 30 days should be allotted to your account. Okay, so man applied for shares of that company, and after 6 months also these shares were not allotted to this holder. Okay, so what happened after some time, when like for after 6 or 7 months, this company allotted share to the person, to this Mr. XYZ. What happened? Mr. XYZ refused that I will not accept this now. Why? Because I have been allotted shares way back, that is 6 months before the shares were allotted to me, and till now they haven't come into my account, so I'll not accept this now. So here the company fired this company filed a suit against this person, telling that we gave him an offer and he accepted that offer. But what happened later? The court decided that the company was supposed to give shares. The company was supposed to allot share within 30 days of application. Within 30 days. So here the time period has been expired of allotting the shares to the demat account of that person. So here this person will this person will be not entitled to accept these shares. This person, you cannot force this person to accept these shares. Why? Because the time period has been expired. So it is very important that whenever you are making an offer acceptance, that acceptance must be within the time period. Okay, time period will be, if time period is fixed, then that acceptance shall be within that fixed time period. If time period is not fixed, then your acceptance shall be within reasonable time. Okay, next is acceptance cannot precede an offer. An acceptance can never precede an offer. That means what? Whenever you are giving an offer, whenever you are giving an offer, first you'll have to give your offer, then only acceptance will happen. Acceptance is the second step. Nobody gave you offer and you're accepting before that only. That is not possible. I never asked you that I want to sell my book, but you came to me one fine day and told me that, ma'am, I want to purchase your book. I said, when I told you that I'm selling this book, I'm not selling this book. So here your acceptance is not valid because offer haven't been made. Okay, I did not made any offer to you, then how you can give your acceptance? So offer can never, acceptance can never precede an offer. Offer will be the first step and acceptance will be the second step. If you are giving your acceptance before offer, how did you came to know that offer was made to you? This is nonsense, right? So first step will be offer and second step will be acceptance. If you are giving your acceptance before offer, you say that I am very minded person. I know I already knew you were willing to sell your book. This is not possible. You're not Antaryami. Like you're not Guruji that you know everything, right? So it is very important that offer will be the first step and acceptance will be the second step. And your acceptance cannot precede your offer. You cannot give your acceptance before offer. Next is rejected offer can be accepted only on renewal. Now, if you reject some offer, like I said, I want to say, excuse me. Like I said, I want to sell my book to you for rupees 200. But you said, no, I don't want to purchase your book. But later on you found that nahi yaar, book ka offer to bilkul sahi tha. The offer of book was correct. I want to purchase this book. So then if you accept this offer now, this will not be a valid acceptance. This acceptance will be valid only when I renew this offer. I renew this offer. So once you reject the offer, that offer cannot be accepted. If you want to accept that earlier offer, then firstly you'll need to renew that offer. Then only that will be a valid offer. Clear, everybody? Do you have any doubt till here? Shall we start the next topic? Okay, so the next topic is communication and revocation of offer and acceptance. Some rules are related to communication, some are related to revocation. Now, what these terms are, we'll discuss in this class today. Like when we were discussing rules regarding offer, we discussed one rule that offer must be communicated. Similarly, when we were discussing the rules about acceptance, again this rule came that acceptance need to be communicated. Now, what is this communication? Like for example, if people are standing hand to hand, okay, if people are standing face to face, they are standing and making offer to each other, there is no question of communication, because I and you are standing in person, and when I tell you that I want to sell this book, immediately this offer came to knowledge of you that yes, I am willing to sell my book. But what happened if people are not in person, if people are not in person, like this act was made in 1872, right? So at that time modes, there were not enough modes of communication. So people used to write letters, like if for example, if I talk about 1996 or 1990s, in that case, if somebody was living in Gujarat and somebody was living in Rajasthan. So if the people of Rajasthan wanted to enter into any kind of contract with people of Maharashtra or Gujarat or wherever, there they used to send a letter. They used to send a letter, speed post, telegram. They used to communicate via these modes. So these rules were more applicable then. But in today's world, these rules are not did not make any sense like they used to make sense in the earlier times. Okay, because now in today's world we have many options available. Like now, if I want to make any offer to you, you are sitting in Kerala, you are sitting in Tamil Nadu, and I'm teaching from Rajasthan. So means of communication is very fast, very immediate. In microseconds, one can communicate his voice to the other person. So now these rules are not so in like not so very effective now. Okay, but in earlier days, people used to communicate via letter. So we'll take an example here and we'll discuss all the points. Okay, so communication is when your offer reaches the other person. When your offer reaches the other person, there you say that the offer has been communicated. So communication will be on behalf of offerer, and communication will be of offer also and acceptance also. So when we talk about communication of offer, we need to make ourselves clear that we are talking about offerer, because if I am making an offer to you, I need to make sure that whatever I'm telling you, whatever I'm willing to tell you, must reach to you. Like for example, if I write a letter saying that, okay, I want to sell my book to you for rupees 200, and when I'll post this letter, when I'll post this letter and this letter reaches to you, that is to the offeree. When this letter reaches to the offeree opens the letter and reads the content, and and it came to his knowledge that yes, some offer has been made to me, then there the communication of offer is completed. So the rule regarding this is communication of offer is completed when it comes to the knowledge of the offeree. When offeree knows that you have made certain offer to him, there the communication of offer has been completed. Now, for example, if I wrote this letter on 20th November, I wrote this letter on 20th November, and this letter reached out to you on suppose 24th November. Then we'll say the communication of offer has been completed on 24th of November. Why? Because on 24th November, this offer reached you. You studied that offer. You came to that knowledge that some offer has been made to you. So there the communication of offer will be communicated. So questions here. will be like this only. There will be case laws, there will be case studies like this only, where people will ask you that on which date communication of offer has been completed. The question will be like this. For example, Mr. A has given his offer via letter, which he posted on this date, and on this date this letter reached to the offeree. So when will the communication of offer be completed? And there will be 4 options available. Okay, so you'll have to make sure that you read that question very precisely, because this you'll get confused in those dates. So communication of offer is very easy. Offer is communicated when offeree gets to the knowledge about the offer. That is, to the person to whom you are giving offer comes to the knowledge that offer is made to me, then the communication of offer is being completed. But complication arises when we ask about communication of acceptance. When is acceptance communicated? So for communication of acceptance, you need to understand that when will acceptance be communicated on behalf of offerer and on behalf of acceptor. Now on 24th November, this letter was reached to you. Okay, you read this letter and you thought that yes, this is a very good offer and I need to accept this, and I need to accept this. What happens on 25th of November? You write a letter of acceptance and you put that letter of acceptance in the post box. You put that letter of acceptance in the post box, and this letter of acceptance reaches the offerer on, suppose, 28th November, and on 28th November that offerer, that is who made you the offer, that is me, on 28th November that offer reached, that acceptance reached to me. Now when I'll open this acceptance and I'll read this acceptance, then the communication of acceptance is completed on behalf of acceptor, on behalf of acceptor. But on behalf of offerer, the communication of acceptance is completed when it is put into the course of transmission. When it is put into the course of transmission. What does that mean? When you will post this letter of acceptance in the post box. When you will post the letter of acceptance in the post box, on that day the communication of acceptance will be completed on behalf of offerer. So when there is a question about communication of offer, things are very easy. That only one rule is there, that when it reaches to the offeree, then the communication is completed. But when we talk about acceptance, you need to clear 2 things, that is acceptance on behalf of acceptor and acceptance on behalf of offerer. On behalf of offerer, acceptance is completed when the letter is being put into the course of transmission. That is when the letter of acceptance, you write the letter of acceptance and you post that letter. On that day, the communication of acceptance will be completed on behalf of proposer, that is on behalf of offerer. But acceptor here is not yet free from his liability. He'll be free from his liability when the offerer receives that letter, when the letter of acceptance is being received by the offerer and the acceptance comes to the knowledge of the acceptor, of the offerer, sorry. So rules are very easy, only through 3 are there in case of communication. If we talk about communication, it's clear that communication of offer is completed when your letter of offer reaches to the offeree. That is when offeree comes to the knowledge about the offer. But when we talk about communication of acceptance, 2 things need to be clear. 2 things need to be clear, that is communication of acceptance as against the proposer and as against the acceptor. The communication of acceptance as against the acceptor is completed when the letter of acceptance has been put into the course of transmission. That is whenever you will reach the whenever you will post this letter of acceptance. And on behalf of acceptor, the communication of acceptance will be completed when the offerer comes to the knowledge about the letter of acceptance. That is when he'll read this acceptance. So on behalf of acceptor, your communication of acceptance will complete on 28th November, because on 28th November your letter is reaching to me. On that day I'm reading that letter, but because you posted that letter on 24th itself, then the communication of acceptance as against the offerer will be completed on 24th November only. That is when it is posted. Okay, any doubt? I hope it is clear. Everybody understood? Okay, next rules are regarding revocation. Next rules are regarding revocation. Yes, we will discuss previous year questions, but once when we'll complete the syllabus, okay? Because completing the syllabus is more important, right? So once we are done with the course, then we'll discuss the previous year questions, we'll discuss your doubts, we'll have test series, etc, etc. Okay, so if you have any doubt regarding previous year questions or anything like that, you can ask me anytime in this chat section or chat section, or if you you can also personally ask me. I'll provide you my cell phone number, so you can ask me there if you guys have any doubt. I am available for you 24/7. So whenever you have any doubt regarding previous year questions, regarding your syllabus, regarding any topic, then ask me without any hesitation. I'm available for you. Okay. Okay, next topic is revocation of offer and acceptance. Now, as we studied that communication of offer is important. Similarly, revocation of offer is also a thing. Now, what does revocation means? Revocation means taking back or withdrawing. Like when we were discussing, when we started this chapter, somebody asked me a doubt that what if we accept the offer, but later on we do not want to perform that. Later we do not want to perform that. Can we take the acceptance back? So today you'll understand that can you take your acceptance back or not. So revocation means withdrawing. Revocation means withdrawing or taking back. Now, for example, sometimes you accept some offer, but then you realize that somebody is offering you something good, something better than this offer. Then you regret that काश ये offer नहीं मिला होता, काश ये offer accept नहीं किया होता, right? Then you regret that I shouldn't have accepted this offer. So for this thing, there is a loophole in this situation where you can reject also. Like rules regarding revocation says that revocation of offer or revocation of acceptance can be done before its communication. Can be done before its communication. Once the offer has been communicated, once the acceptance has been communicated, then you cannot revoke. Then you will be bound to perform it. Like for example, I wrote a letter to you that I want to purchase, I want to sell my book for rupees 200. You accepted that offer. You accepted that offer and you posted the letter of acceptance on 24th November. But this letter will reach to me on 28th November. Before 28th November, you have all the option to revoke your acceptance. You have all the means available to revoke your acceptance. Now, for example, you found that no, this offer is not worth it. I don't want to accept this, but you have already sent your acceptance letter. There, what you will do, you will write one more letter that I am not accepting this offer. I am not willing to accept this offer. What you'll have to do, you'll have to just write it and you'll have to speed post it so that the letter of revocation reaches earlier than letter of acceptance. If the letter of revocation reaches early, then your revocation will be valid. That is, now you do not need to perform. Why? Because the revocation is done before the communication of acceptance. So you can revoke your acceptance anytime before its communication on behalf of acceptor. Before the completion, that is before it reaches to the knowledge of the person. Before that, you can revoke your acceptance at any time. But once the letter of acceptance has been reached to me, once I have read that letter of acceptance, after that you cannot revoke your acceptance. After that, you will be bound to perform. Like for example, on 28th November, your letter of acceptance reached out to me. Your letter of acceptance reached out to me, and now you are willing to reject this. Now you are willing to revoke this. Here you will not be able to revoke this offer. You will not be able to revoke this acceptance. Reason being, the communication of acceptance has been completed. So once the communication of acceptance has been completed, after that you cannot revoke. You cannot take back your acceptance. Then you will be bound to perform. Similarly happens with offer also. Like I gave you this offer, but meanwhile I received another somebody else came to me and told me that I will purchase your book for rupees 300. Now I have given already an offer to you for rupees 200. That means what? There will be a loss of rupees 100. There will be a loss of rupees 100. So I will think that if you do not accept this offer, that will be great. So what will I do? I will write one more letter to you. I will write one more letter to you saying that I am not willing to give you any offer. I am not willing to give you any offer, and I'll speed post it. If my letter of revocation of offer reaches earlier, then my offer can be revoked. But once the communication of offer has been completed, your offer cannot be revoked. That is on 21st November, 24th November, this offer letter was supposed to reach you. Okay. So after 24th November, I cannot take my offer back. Similarly with acceptance, once the communication of acceptance has been completed, acceptance cannot be revoked. Once the communication of offer has been completed, offer cannot be revoked. After that, you'll be bound to give your performances. Beta, you can Google it. You'll find on the website also. If you Google it and you'll write previous year examination questions, you'll get that. Okay. So these are certain rules regarding revocation and communication of offer and acceptance. Anybody has any doubt regarding this topic? Okay, I hope this topic is clear. Now we'll be discussing about how can an offer, in what situations the offer can be revoked. Firstly, offer or acceptance, how can it be revoked? Firstly, by communication of notice of revocation by proposer to the other party. Once the letter of revocation has been posted, your offer is revoked. Okay, that we have already discussed in the above 2 points. Second is by lapse of the time. Sometimes when time is decided or when the reasonable time period has been expired, then your acceptance is not valid. Okay, we have already discussed this point in acceptance, that acceptance must be in a prescribed time limit also. Okay, so if your time period expires, if you give your acceptance after expiry of time period or after expiry of a reasonable time, then your acceptance will not be a valid acceptance. So if you want to give a valid acceptance, then you have to make sure that acceptance must be within the time limit. Acceptance must be within the time limit. So if you are giving your acceptance after the expiry of this time period, then your offer will revoke, your offer lapses. Now the offer will not be valid anymore. Next is by the failure of the acceptor to fulfill conditions precedent to acceptance. Sometimes what happens, like offer contains conditions also. Like I told you that I will give you this book only when you give me 100 rupees advance. So now one condition is also attached to this offer, that is you need to give rupees 100 in advance if you want to purchase this book. Now if you fail to fulfill this condition, like you are willing to purchase my book but you fail to accept this condition, that is you fail to give rupees 100 advance, then also your offer is revoked, then also your offer lapses. That is now this offer will not be valid. Why? Because you failed to accept the conditions precedent, that is you fail to accept the conditions attached to that offer. Okay, next is by death or insanity of the proposer. If the proposer, that is if the offerer dies or became insane, insane means lost his mental faculties, that is not able to think properly. Now he has lost his mental faculties, there that person is known as insane, mad. Okay, so if the proposer dies or become insane, then also your offer lapses, then also your offer is no more valid. Now I gave you the offer and if I dies, then in that case you'll not be give acceptance, you'll not be able to give acceptance to somebody else. So here your offer will be cancelled, your offer will be revoked. Or if I became insane, that is I am mad now, in that case also I'll not be able to take a rational decision. So law does not allow a mad person to enter into a contract. So technically you'll not be able to accept this. You'll not be able to give your acceptance. Okay, so in these both the two situations your offer will lapse, your offer will revoke. Next is if a counter offer is made. We have already discussed a counter offer. What does counter offer means? Counter offer means that rejection of original offer. The definition of counter offer itself says that it is rejection of original offer. So here your original offer is ultimately rejected. Here you do not accept the offer as it is. You make some changes in the terms and conditions of the offer. So a new offer is being made while you are making a counter offer. So anyhow there is rejection of original offer. So the original offer, that is initial offer at the time when it was made, that offer lapses, that offer has been revoked. This point we have already discussed in the starting of the chapter, that is counter offer. That is why I'm not giving you an example again, because that is similar. Next is if an offer is not accepted according to prescribed or usual mode. Like when we were discussing about the rules about acceptance, we discussed one rule, that is you need to give your acceptance in the prescribed manner. If I asked you to give your acceptance via WhatsApp, then you'll give your acceptance via WhatsApp only. If you're calling me and giving your acceptance, that will not be a valid acceptance. So if you fail to give your acceptance in the prescribed mode, then also the offerer may take back his offer, may take back his offer. So there also your offer may lapse, your offer may revoke. And last is change of law. Sometimes what happens, the law changes, the law changes. Now for some time plastic was valid in Rajasthan, but in 2023 the state government banned the usage of plastic in Rajasthan. Now what happens, whosoever is dealing with plastic, all will have to stop. all will have to stop because the law has been changed. Now the use of plastic is considered illegal in your state. So here, due to change of law, all the offers you have made earlier are null and void, that is, now these offers will no more be valid. So you need to make sure that if the law also changes, then also your offer gets revoked, your offer lapses. So these are certain circumstances where you don't want to cancel your offer, you don't want to revoke your offer, but ultimately the situations are so that your offer gets revoked, your offer gets revoked, your offer gets lapses, your offer is cancelled, one and the same thing. I hope everybody understood this. Next topic is void agreements. Here there are certain agreements which the law declares void. We'll not be studying this topic right now. Reason behind this is each and every point will be discussed in the coming chapters. Each and every point will be discussed in the coming chapters. So if I'll try to teach you this right now also, then also you'll not be able to get the entire thing, because for understanding these points you need to understand the history behind these points, and that will be clear only when those chapter will be discussed. Okay, so if I'll discuss everything right now, then you might not be able to grasp everything. Okay, so we'll be discussing this point, that is void agreements wala point, will be discussed whenever there will be chapters. Okay, so whenever this point will come in any chapter, I'll let you know at that time only that here this thing is void. Like for example, we studied one thing, that you cannot enter into any kind of agreement with a person who is not above the age of 18 years. So one of the point here says that you cannot an agreement with minor is void. Similarly, many more agreements are void which will be discussed in earlier chapters. So we'll discuss later. Next topic will be capacity of parties. Next topic will be capacity of parties. This topic will be discussing in the next class, but I'm just giving an overview to you in this class that what capacity means. Capacity means eligibility. Capacity means eligibility. That is who all are eligible to enter into a contract. Like when we were discussing about essential elements of a contract, we already discussed that the parties need to be competent. If the parties are competent, then only they'll be able to enter into a valid contract. So today we are in the next class we'll be discussing this point, that how a party will be competent to enter into a contract. Who are competent persons? Who are competent person? That is, who are allowed to enter into a contract. First, I have already discussed that minors. Who are minors? Who have not attained the age of 18 years. But when something is related to property, then age of majority is 21 years. But rest in other situations, the age is 18 years. So if a person has not obtained the age of 18 years, he is not allowed to enter into any kind of contract. He is not allowed to enter into any kind of contract. Similarly, if person is mad, if person is insane, if he cannot take a rational decision, if his mental faculties are not proper, they are not allowing him to take a rational decision, then also that person cannot enter into a valid contract, cannot enter into a valid contract. Similarly, there are certain other disqualified people also that we'll discuss day after tomorrow. I hope everybody understood whatever we have studied today. If there is any doubt, ask me here itself. Those who don't have any doubts can leave this class, okay? Because today's topic is completed. We are done today. You have a lawyer or you are a lawyer. If you're asking that if I am a lawyer, then yes, I am a lawyer. And if you're asking that if I have a lawyer, no, I don't have any lawyer because I myself am a lawyer. I have completed my law degree a year ago. So technically, yes, I am a lawyer. Don't feel sorry. You can ask me anything. I hope you all are understanding everything. Uh, Everything is clear, whatever I am teaching. I hope. If you have any doubt, ask me there and then. If you don't want me to discuss your doubts here, I can also reply privately to you so that only you can understand. Okay. So don't hesitate if you have any question regarding topic, regarding not regarding topic also. Okay. So do not hesitate because in the first class itself, I told you that we'll act more like friends rather than teacher and student. Okay. So do not hesitate to ask me anything. The age of majority is 18 years only. The person who has attained the age of 18 years becomes a major. Okay, before attaining the age of 18 years, he is considered as a minor. 21 was for property. If the case is related to property, then the age of minority is considered as 21 years. But according to Contract Act, according to your syllabus, the age of minority is a person who is below the age of 18 years. But when there is any case regarding property, then in that case you need to be 21 years old to fight in your own name. Okay, so there are two ages of majority. One is above 18 years and only in case of property etc. it is 21 years. But for your course it will only be 18 years. What is YT? No, I don't teach on YouTube. I generally teach here and then I teach personally in Rajasthan. I take batches of law in Rajasthan itself, but this is my first online session. I don't use YouTube. Sorry. Welcome. अगर आपको notes चाहिए तो you can ask me. I'll give you notes. Okay, I don't have any problem because I have self-made notes also. Apart from your modules, आपके modules के अलावा भी मेरे पास में मेरे खुद के notes बन रखे हैं. So if you want those notes, I can provide those also. And if you don't understand something here because of a short time period, or if you lack something, these lectures are recorded. Okay, these lectures are available on the website of CMA. Okay, so you can visit this website and you can uh, like you can revise all these lectures again. Okay, I'll upload it here. In the next class, I'll upload the notes. Okay, so it will be easier for you to understand because notes are a bit simplified. थोड़ा simple language में है, तो आपको easily समझ में आ जाएगा वहां से. Okay, I hope everybody's doubts are clear now. Shall I stop this class, or you have anything more to ask? Okay, thank you everybody. Have a great night ahead. We'll be meeting day after again. Hope you all understood whatever we studied today, and hope you're getting everything, and hope I'm able to clear all your doubts. Okay, thank you everyone. Goodbye.